I want to talk about Medicaid estate recovery in Florida. There are plenty of clients who are understandably apprehensive about starting the Medicaid process, the Medicaid planning process, because they say, doesn't Medicaid have the right to come after your stuff or to collect what they've paid after a Medicaid client passes away or after a Medicaid recipient passes away? And the answer is that is true, but what a good elder law or Medicaid planning attorney in Florida is going to be able to do is drastically minimize and often eliminate entirely what would ever have to get paid back to Medicaid. And the reason is, Florida certainly has some of its drawbacks, but one thing that they have going for them is Florida has a lot of very valuable Medicaid planning tools that are not available in other states, and has a fairly standard, unenhanced Medicaid recovery process. In other words, other states are more aggressive in what they'll go after a client passes away. Florida's is relatively benign. So essentially, with Medicaid planning in Florida, there are really two scenarios where Medicaid estate recovery would ever come into play. The first is there a probate? Meaning, do you have to go to court after someone passes away to get assets to the next generation? And if there's a probate, every judge in the state of Florida will require anyone over the age of 55 to put Medicaid on notice. So they don't even have to know whether you're on Medicaid or not, but they'll make you put Medicaid on notice to give them an opportunity to submit claims. Okay, obviously, if you were never on Medicaid, there'll be no claim, but if you were on Medicaid, they'll have the opportunity to submit a claim. So, as part of what we're doing as Medicaid planners, we're also estate planners, because estate planning a lot of it is surrounding the concept of let's avoid probate. Because even if you don't have creditors, probate takes up a lot of time. You have to pay a lawyer more money, and it's just a pain in the butt. And we can avoid probate. That's always going to be better in nearly almost every situation. Not always, but nearly almost situation doesn't make sense to avoid probate. But if you're on Medicaid, avoiding probate is even more important, because that's one of the primary times that Medicaid has an opportunity to have their hand out and say, hey, we paid for Mrs. Jones, we paid hundreds of thousands of dollars toward her care. We want that money first. And if they are given that opportunity, they will get paid first before family or anybody else. Just like if you don't pay Visa or if you don't pay any other creditor, creditors are given an opportunity to recover before family members through the probate process. There's some exceptions to that. For example, there are some assets that even if they go through probate are not subject to creditors, such as the homestead, right? If your home was still your homestead when you passed away, even if you were on Medicaid, if that's the only asset that goes through the probate process, while they'll submit a claim, it will not be successfully reimbursed to Medicaid because the homestead is so sacred in the state of Florida. That's unlike, by the way, other states. Other states that don't have as strong protections on the primary residence. So, but again, why even go through that? Why even give them an opportunity? Let's just avoid probate entirely. So with real estate, we're usually having a discussion about a ladybird deed or using a revocable living trust. And with all other accounts like IRAs and bank accounts and anything else that the family might have, we want to make sure that those assets are structured properly so as to avoid probate. If there's no probate, Medicaid is not given an opportunity to submit a claim and ask for money back. Now, there are a couple of other opportunities for Medicaid in Florida to get some money back, which is depending on what Medicaid planning strategies you use. For example, there are something called Medicaid compliant annuities. I actually use them very, very rarely. They rarely make sense in Florida because there are so many other planning opportunities, but every once in a while they will make sense. But Medicaid compliant annuities, a feature of it is you're increasing the Medicaid recipient's income, but if they're not survived by a spouse, then the remaining payments typically have to go back to the state first. That's just a feature. That's why they're Medicaid compliant. Similarly, we sometimes talk about pooled special needs trusts. pooled special needs trusts also have an obligation to put Medicaid on notice and to satisfy their lien out of funds that are remaining in the trust when my client passes away. And then only if there's anything left over does the family have a chance of getting anything. So again, the pooled trust may be one of 3 or 4 different strategies that we use. And so then we want to think about that strategically, because we don't want to just throw everything into a trust, although it's nice because it keeps the client liquid and able to pay for anything that they need or want during their lifetime. But we want to limit what's in there. And if we could time it properly, set it up so there's either nothing left or very little left by the time my client passes away, so that, again, we are eliminating or significantly reducing what would have to get paid back. And that's really it. There's really no other opportunity. So with proper planning, again, Medicaid will not get 1 red cent, or get very, very little with proper planning if you're working with an experienced Medicaid planning attorney. And if you're anywhere in the state of Florida, hopefully you'll consider us. There's one other theme I want to address, which is, let's say you did have to pay everything back to Medicaid. You don't. We're gonna be able to eliminate or reduce it drastically, but let's say you did. You would still come out on top. Medicaid planning would still be worth it, because Medicaid pays at a substantial discount compared to what you'd be privately paying. So when people go, well, I don't want even the chance of paying anything back to Medicaid, and I say, well, all we're doing is giving you or your loved one access to more resources while they're alive, and you're gonna get them at a discount, right? I mean, and if there's nothing to pay back to Medicaid, then you just receive the services essentially for free. But if you did have to pay something back, you're paying back very little compared to the value you've received or your loved one has received over the course of their life, receiving long-term care services through Medicaid. So it's a win-win no matter what. So anyway, I hope this explains things a little bit further. But again, I don't want you to think that I'm focused on what you have to pay back to Medicaid. I'm very much focused on let's reduce or eliminate what has to get paid back to Medicaid depending on my client's situation and assets and what we're protecting. So if you're interested in talking about Medicaid planning anywhere in the state of Florida, or estate planning, or probate, please give us a call, schedule a consultation. If you found this video useful, please give it a thumbs up, please share it, put in a comment. I am happy to answer questions. And thank you for helping me make Floridians more educated legal consumers. Thanks for watching.